Good afternoon, everyone. Welcome to part 4 of Medicaid Mondays in March. We're running out of March and we're running out of Medicaid Mondays. So part 4 today is nursing home care. Part 1 was basic Medicaid eligibility. We built on that in part 2 with Medicaid asset protection trusts. Part 3 was Medicaid home care specifically. And today we're going to take on the challenge of Medicaid nursing home care. Our firm is Pierro, and Strauss. We are based here in Albany with offices around New York State. And this is our cast of characters. Partners, myself, Aaron Connor, Peter Strauss. We now have Karen Kepler down in our New York City office, along with Harvey Schneider, and our associates on the bottom rung, including the senior associate to my left, Mr. Frank Hemming. Hello, Frank.
Hi, Luke. Thanks for having me back again.
And Frank, if you don't know already, is our in-house Medicaid attorney. He has become a very astute and very well experienced Medicaid attorney and represents clients in all counties across New York State, in effect, down to Long Island, New York City, HRA, all the way out to Buffalo. We've done Erie County up to Plattsburgh, Clinton County. And so Frank is going to lend you his expertise today in dealing with Medicaid applications for nursing home care. And our agenda for today is to look at the steps you can take to qualify for Medicaid, look at a brief refresher of the numbers. We covered that exhaustively in session 1. Again, exempt transfers, we covered that, but we're going to give you a little refresher today in case you missed those first sessions. And then how to preserve non-exempt assets for someone who is either entering or is already in a nursing home. And then finally, how to get into a nursing home, because when you do the discharge planning from a hospital, you go to rehabilitation. Very often you have to file with the nursing home a very comprehensive financial application. And for many families, that's the first time they call us, right? Because they're being called on to assemble this world of information. And very often it's a caregiver child or someone who's trying to put this together, sometimes a spouse, for someone who's in the hospital and can't help, can't provide that guidance. So how do you gather up the necessary information? How do you get someone from point A to point B, from hospital to rehabilitation to skilled nursing facility? We talked about how to get them home in our last session, and that's something that we work on frequently. But if a nursing home is necessary, how do you get that admission and make sure that everything is done properly? Sometimes that takes advocacy and looking at alternatives. So the chronic care Medicaid application, as it's called, is the nursing home application. And that's something that we all need to be familiar with. And we're going to go, we did already the home care. We're going to talk about the nursing home here. But remember, there's a 5-year look back for Medicaid nursing home care. And that's something that you need to be aware of. We'll talk more about that as we go. Community Medicaid, just to remind you, does not currently have a penalty period. It does currently have a look back period. And you may think to yourself, well, how can I have one without the other? And the answer is that the state put in new rules as of October 1st. So transfers made today will at some point be subject to a look back, but those rules have not yet been enforced. July 1 is the next target date for enforcement, but we're hearing that that may again be put off into the future a little bit further. So the startling thing for me as an older practitioner, can I say that? Someone who's been practicing law for 36 years, when I started, nursing homes were very different places. And the cost of nursing homes was extremely lower than it is today. But Frank, we are experiencing this with our clients. When they come in, they get that first bill from the nursing home, not for 1 month, but 2, because they have to pay a month deposit, and they come in with this look on their face. How did this happen?
Yeah, and honestly, the numbers in front of you, while they are large, we're actually seeing higher numbers than that in reality. The highest, most expensive facility in this area costs about $17,000 to $18,000 a month. So while those numbers are large, in real life, they can be even larger than that.
Okay. These are numbers that were gathered by Genworth Insurance Company. They do a cost of care study. These are artificially low. The other thing you have to remember is that for nursing home care, there is a surtax imposed by the state of New York of 6.8%. So just take these numbers and add another 6.8%, and you get a little bit more of a flavor for the real cost. But those numbers have even been inflated further. And now we're seeing somewhere $15,000, $16,000, $17,000 per month, which when you do the math, it's $180,000 per year. How long can people write that check without just depleting all of the assets? And I've had people come to me over the years saying, well, we need to get Medicaid for mom. She had $200,000, she spent it all down, and now she's down to where Medicaid will qualify her. Okay, why didn't you come see me $200,000 ago? And we could have done something. And we're going to talk about that today. What can you do for nursing home care? And in order to do that, you need to know what the numbers are.
So with the numbers, there's kind of a new addition to this slide. So the new addition is for the individual in the nursing home, your income allowance is $50. So to make this very simple, what happens when you get on Medicaid is they take all of your income except for $50, and that's your monthly NAMI payment to the nursing home. If you hear me say NAMI, that's just what that means. That's your monthly income payment to the nursing home for Medicaid.
Available monthly income.
There you go. When we talk about assets or resources, they're the same numbers as we talked about earlier on the community program. So if you're one individual in the nursing home, it's $15,900. If you have a couple, you actually get two individuals, so they each get $15,900. The other numbers worth noting here, which we're going to talk about later, is up top, the minimum monthly maintenance needs allowance, that MMMNA number of $3259.50. That's what the community spouse can have if, for income purposes, if their spouse is in the nursing home. And then that bottom number, that community spouse resource allowance, or CSRA, is $74,820, or up to a spousal, or half the combined spousal share, up to $130,000. But again, when the new rules take effect, that number is going away. So I don't usually like to spend a lot of time on it because it's not here to stay for very long.
So we're going to talk about these numbers. Forgive us, we're lawyers, we acronymize everything. So the MIMNA and the CISRA, we're going to talk about it with an example, a case study later on, and talk a little bit more about those rules for spouses, because spouses do have special rules available to them. But the bottom line for a single individual is you have to get down to $15,900 of assets with certain exceptions. And these are very critical exceptions, Frank.
They are. So what are some of the exceptions? Your home, right? As long as you, your spouse, or a disabled child lives in the home, up to an equity limit of $906,000. So we don't typically see issues with that equity limit upstate. Downstate in New York City, on Long Island, and other wealthier parts of the state, that could become an issue. So just so you know, it's not an unlimited number. That automobile is usually a fun one to talk about clients, because if you notice, there's no equity limit next to that automobile bullet. It doesn't matter how much your car costs or how much it's worth. As long as you only have one, you can have one, regardless of its value. If you prepay for your burial and funeral arrangements, those are also exempt because Medicaid wants you to pay for those things while you can.
So we're not going to talk in depth today about estate recovery. We'll do a little bit of that next week. But know that anything that's in your name upon your death, if you do go on Medicaid, including that car, is a recoverable asset. So if you buy the $100,000 Bentley and you have that at the time of your death and you haven't changed title and it's part of your estate, you're going to win short term, but long term, Medicaid is going to come back and collect against that car. So there's planning that's needed all along the way. And there are some other very special exemptions.
So if you have an active business that's actively producing income, your business is an exempt asset. We don't see that one very often because we don't have a lot of people that have active businesses and need the nursing home. But if you happen to meet that criteria and that scenario, your business is exempt. The income from it would not be, but the business asset itself, that's exempt. Your life insurance, you're allowed a very limited amount of life insurance. So if you have a life insurance policy with a face value at less than $1,500, your life insurance is exempt. If you have more than one policy, they aggregate, they add up all of the face values. For all of your policies, if it's more than $1,500, they all count. So that's why you can't have very much of life insurance.
And that's death benefit. That's not cash value.
Correct.
So if you have $1,500 of total death benefit, that's all you can keep. And the cash value, a lot of people get tripped up on this. The cash value of your life insurance is a countable asset. So then it would go against that $15,900 allowance.
Exactly. Good thing to know and a good thing to distinguish. Last bullet is a very big one. That's your IRA or other tax-deferred retirement account, as long as it's in periodic payment status. You have that happen automatically when you get to be 72. If you're less than 72 and have such an account, we put it in payment status early to exempt it. So we use that one all the time, because as we see more and more seniors need help, more and more people have IRAs or other similar retirement accounts that they don't need to spend down.
So you use a life expectancy table. The IRS publishes one. Many counties accept that one, but some counties require a social services table to calculate the amount of your monthly payment. And that monthly payment has to be paid out. That becomes your income. But when you're using the income from a retirement account, and so far Roths do qualify for this. If you're drawing the income, it goes toward the cost of care, and the rest of the account, the balance, the principal of the account, remains exempt. So IRAs in New York are exempt if in periodic payment status. If you flip the border to Massachusetts, Frank,
not exempt anymore.
And in most states, in fact, they do not exempt IRAs. Major change for people. We have a lot of clients that move to the Carolinas or move down to Florida. Well, if you move to South Carolina, your IRA is available if you need Medicaid. If you move to Florida, it is not, because Florida follows New York's rule. These are state-specific rules. So if you plan to move, you need to know where you're going and what the state law is there. And we counsel a lot of clients through that process. So there's a 5-year look back, Frank. If you have assets over and above that $15,900 that are not exempt and you give things away, there are penalties.
There are, and there are a lot of examples on it. You know, we put some of the more common ones that we hear on the slide, where we ask people in that consultation, have you given anything away in the past 5 years? And most of the time people say no. And that's sometimes true, sometimes it isn't, because at some point, if we're going to do this application, we're going to audit your finances for the last 5 years, and we're going to see what you did.
And that's critical to do that 5-year audit before you apply for Medicaid.
Because we want to know what's hiding in there, right? So if you gave something away, essentially for nothing in return, that's a gift. Whether you think it's a gift or not, that's what a gift for Medicaid purposes means. So some common examples, when you gave that money to that grandchild for their college tuition, or you gave the vehicle that weren't going to use anymore to the family member for $1 just to clear the title, or if you make large gifts to your church or some other organization that you want to support, those are all gifts for Medicaid purposes. So they get thrown into the equation when we're doing eligibility.
Or the one I hear all the time, Frank, well, I've never given anything away in the past 5 years. I just put my children's name on my deed.
Well, that's a gift, right?
And that the value of the home is then gifted away, and you have to calculate it into that 5-year calculus. We're going to look at an example of how that works in just a few minutes, but there are some exemptions, Frank.
Right. So if you're transferring something to a spouse or a disabled child, that's an exception. You're allowed to do that free of penalty. Spouses can always gift to each other, which we commonly do to get eligibility for one spouse, and we put everything with the well spouse. Or if you have that disabled child, it's one very lucrative planning opportunity that if we use that to our advantage every pretty much opportunity we can, because that's free of penalty.
Call it a major loophole. A child with a disability, and it could be veterans disability, SSI, SSDI, Social Security disability, any qualified disability for a child, unlimited amount of assets can be transferred without any Medicaid penalty.
Correct. And then we have your house, your home. So if you have a caregiver child where they've been residing in the home for at least 2 years, providing the requisite level of care, or if you have a sibling with an equity interest, you can also transfer your house free of penalty. We don't like to use those as much as the spouse or disabled child, because those have kind of criteria that go with them. But if those are the ones available, we use those too.
And then there's the 5-year look back, which most of you have probably heard of. Most people don't really, though, know how it works or what it means. So when we're talking about the look back period, Department of Social Services or the HRA, Human Resource Administration, if you're in the 5 boroughs in New York City, you have to submit a complete comprehensive application with every financial record. And this is where a lot of people get tripped up who don't have representation going into the Medicaid application. We do the due diligence, and make sure that every document is in place, that every schedule is completed on the application, and that we've reviewed and, as Frank said, audited every application. But that 5-year look back period becomes critical when you're applying for Medicaid for a nursing home, and you want to know what happened in that period, because once they find transfers, there is a penalty period or a waiting period that's assessed based upon the value of what you gave away divided by this number.
Correct, the penalty number, as I always call it. So the number for the Capital District is 11,689. That's kind of towards the middle. It's more expensive downstate, so in the city on Long Island, and you get to the northern metropolitan region, and then it gets a little lower when you get more towards the middle of the state. But those are the numbers that they use when they find how much money you've given away in that 5-year period. They then take the total, divide by these numbers, just depending on which region you're in.
So Frank, how does all this work and what does it mean?
So let's take a quick example. So if we do that 5-year audit, we find that you gave away $140,268.
Nice round number.
I know. It's amazing where I came up with that number. If you take that number, divide it by 11,689, you get 12 months, right? You get 12 months of time where you have to be private pay in the nursing home before Medicaid will start paying for you. So the other part of this isn't so much what the penalty is, but when does it start to run? And you have to meet some criteria for that, just like everything else with Medicaid. There comes with criteria. So the penalty starts to run when you're actually in the nursing home and receiving that care. You're otherwise eligible, meaning you're down below that $15,900 resource limit that we keep talking about, and you file a Medicaid application. Up until those 3 things are satisfied, your penalty isn't running.
And this didn't used to be the law. Before Frank's time, when us old timers practiced, and you had a law change in 2005, the Deficit Reduction Act of 2005. It used to be that you could give assets away and the clock started running right away. You'd think that makes logical sense. If I give my assets away, I've created a look back and a penalty period, and that penalty period should run. They tricked it up and put a trap in, and this is the trap. And this is because of that change in the law, so that now, if you've given assets away in the prior 5 years, you have to be otherwise eligible, which means you have to be already spent down to $15,900. You have to be in a nursing home, and you then file your Medicaid application, and that's when the penalty period gets imposed. But Frank, that raises an obvious question.
Yeah, what happens, right? Because if you gave all your money away and you haven't earned your penalty, then you submit your application, they find what you've done, and then they penalize you for it. You don't have any money to private pay with anymore because you gave it away. So the question we get a lot, unfortunately, is if this is the scenario you're in, what happens? Well, real life, the nursing home really has no incentive to want to keep you because you don't have a payment source. So one thing we see is if those monies or those properties or whatever it is that was gifted away, if they can come back, we give them back. And then we start square one and we do a new plan with everything. Yeah. If we can't do that though, then we're kind of in the pickle.
No money, no Medicaid, no admission. That's the bottom line. They want to have one or the other. They want to know if you think about it, if you're an admissions director at a nursing home and you're looking at applicants and you want to know whether that applicant is going to be paid for, that bed is going to be paid for, they either have to have the resources to pay or they have to have a Medicaid number. And the delays in the Medicaid application process we'll talk about toward the end. But this is an important thing to remember, that now with these penalty rules, you have to do this 5-year audit. We very often have to advocate with the nursing home admissions people to let them know that we've done the numbers, we've done the calculations, and we've done it enough times, Frank, that we very rarely miss, if ever.
Yeah. I
don't think we've missed an application deadline or a date yet.
No.
So
thankfully.
You want to know that it's done right. And you want to know that Medicaid is going to be there when you need it. Not only do you want to know that as a family member or a Medicaid applicant, but the nursing home really wants to know that too. They want to know that they're going to get paid. Because if you're 12 months in a nursing home bed, what are they going to do with you? They're going to, oh, they have an infection, we're going to send them to the hospital, and they're going to give your bed away. And they're not going to readmit you. We've seen that happen on a very regular basis for people that have no payment source. So it's important, Frank, to know the rules and know how these rules work.
So what do we do if you have assets, you haven't done any previous planning, or you're already in that nursing home and you still have money that you haven't spent down yet? use the strategy that we now have in front of you called the Rule of Halves. We've been doing this a long time. I've been doing it for my 6 years here at the firm. Lou can actually tell you the full history about it and where it came from and why it works. But essentially what we do is we take all the numbers, we throw them all together in a very complicated calculation, and we come up with roughly a way to save roughly 50% of what you have from going to the nursing home.
And if you ever want the whole story, it's a good bedtime story. I can put you right to sleep talking about the history of Medicaid applications. But suffice it to say that when the law changed, we litigated. We went to fair hearings. We sued the state to carve out territory where we could still do something for individuals without bankrupting them entirely. So this is how it works.
So let's look at a real life example. So we've got Bob, and Bob needs help in the nursing home. He has income that comes in every month of $33.11, and he has $349,000 of non-exempt assets. So that could be a stock account, that could be all kinds of things. Of note, he's already given away $100,000 over the past 5 years. So we know about that. So we're going to throw that into our calculation. His nursing home costs $15,000 a month. That's a common number that we see in the Albany area. So first, what do? First, we have his family prepay for some things right off the top. So his funeral, some television, some clothes, some furniture, his legal fees. So we're going to spend him down just a little bit. So let's say we spend him down $33,590. We spend down. Before Medicaid's involved, that's fine. Those are all legitimate spend.
And this is your shopping spree.
Yeah, go spend money.
You can spend money without giving it away, if you can, but it has to be for the benefit of the individual. We have a case that we've heard of, it's not our case, that we heard of down in New York City, where someone went out and brought in receipts for 5 television sets. Well, that's not 5 television sets going in a nursing home room. One of those maybe, but the other 4 are going to be penalized transfers. So you got to play by the rules, but you can spend on anything. And if the person has a home with a life estate, they can fix up the home. They can spend money on a variety of things. This is where we get creative to help people utilize funds to do things that are necessary. And the funeral and burial, Frank, can be for any immediate family member.
Yeah, and believe it or not, in-laws are actually included for certain family members.
So if you want to bury your son-in-law, no. If you want to pay for his burial, you can do it. And it's an exempt transfer for Medicaid purposes. So that's another tool that people use to spend down. But once you get all of that done, you still have non-exempt assets.
Right. So in our example, once we do our spending and we take off his allowance that he's allowed to have, now we're down to $300,000. So we're going to gift away $100,000. So if you do the total math, right, we've gifted $100,000 now. He previously gave $100,000 before, so he gifted $200,000 total, and we're going to loan $200,000 total to his son, all before the end of the month, because Medicaid looks at what you have on the first of every month. So if we were doing this now, we have to get these transfers done in March, so that way we can start the clocks ticking as of April.
And this works whether you're going in or whether you're already in. People who have been paying privately $15,000 a month can still do this planning even at that stage. And the results are pretty important, because now we have income, and we have income a total of $33.61. You get the $50 allowance. That gets us to our net of $33.11. And again, the numbers are fictitious and they fit pretty nicely into what we're doing. So $15,000 cost, $33.11 of income going toward the nursing home, $50 a month going into the patient account. Now we have a deficit or a shortfall of $11,689. That's what we have to come up with in order to private pay the nursing home during this waiting period or penalty period, because we're already in the nursing home. We're going to get down to $15,900, and we're going to apply for Medicaid to trigger the penalty. So we start with $349,490 in total assets. We do our spend down. That includes legal fees and all the other things Frank mentioned. We leave $15,900 in the individual's account. That's exempt. And now we have at-risk capital, or available assets of that $300,000. If we hadn't done the $100,000 of prior gifts, we could save $150,000. But because we have to account for those prior gifts, we now have to put that into the calculus, and we can save a significant amount, Frank.
Right. So here kind of how the numbers work out in total. So if we gift that $100,000, in addition to the old $100,000, we've gifted away a total of $200,000. To figure out what our penalty is, we divide it by that penalty number from earlier. So if we do the division, comes out to a 17-month penalty. Well, that's great. But now we have a problem because now we have 17 months of private pay. Where's that money going to come from? So that second 200,000 that's still left with Bob after we make our $100,000 gift, we then loan to the family. And if you do the math, it works out quite nicely that for the next 17 months, we're going to do a loan payment back to Bob for $11,689, the amount that he needs to pay for that nursing home for that 17 months. As long as we submit our application in the next few months for a pickup date of April 1st, that starts the clock. So the penalty and the note both run for 17 months from April 1st up until September of 2022 next year. And then come September 1st, now Bob's on Medicaid, and we were able to save all that money for the family while paying the nursing home during that time of ineligibility.
This is, as you can see, a very complex calculation. We actually have software that we put all the variables into that give us the optimal transfer value and the amount of our note, and then it prepares the promissory note. So the question of who files Medicaid applications, if this doesn't convince you that it takes counsel to do it, I don't know what will, because these are tremendously complicated calculations. And if you miss by a month, what does it cost you?
Another $15,000.
15 grand. So you don't want to miss. And that's really the point. So the net result here is Bob has saved $235,860 of assets, even though he's in a nursing home, the prior gift of 100, the new gift of 100, and we have the other expenses, the things that were purchased for him, his exempt account, all adding up to $235,860 from September 1, 22 on. Medicaid is the payment source. Our nursing home is satisfied with, and we present these numbers to them. We're going to private pay for the next 17 months. We're going to have Medicaid at the end of that 17 months. We're on a pretty first name basis with most of the nursing homes. We're very friendly with them. They know that we do the calculations well. And so it's something that we can offer as a service. We mentioned married couples having a little different play, and there are different rules if you have a spouse, healthy spouse living in the community. So the spousal impoverishment rules that Frank mentioned earlier, the MMMNA and the CSRA, the minimum monthly maintenance needs allowance, is the amount of income that the community spouse can have, and the resource allowance, the amount of assets that the community spouse can have. In New York, they opt for the higher of the payments, $3259.50. That's how much income the spouse in the community gets, and that can be their own income, or you can actually allocate income over from the nursing home spouse to the community spouse, and then they would get up to that $3259. What if the community spouse themselves has income over the $3259? They're asked to make a voluntary contribution of 25% of their excess income. That's the ask from the county if the community spouse has income of their own above the $3259. I won't go into the history of the 25% voluntary contribution, but I was there when it happened. So these are the income and asset allowances. As Frank said, the rules are changing once they implement the new rules. $74,820 will be the amount that you can have as the community spouse, in addition to the $15,900 of the institutionalized spouse if you are in the community and a well spouse. There's a lot of what we call post-eligibility planning that happens. The other thing that can happen, Frank, is spousal refusal.
Right. So we use this as a very common planning technique where we shift all the assets above the allowance of $15,900 to the community spouse, where they then shelter everything themselves. And to get eligibility for the Medicaid spouse in the nursing home, the community spouse signs a document that we call a spousal refusal, where they refuse to turn over their income or their assets or both, depending on their situation. And which basically, the reason why we do it is because when you execute that spousal refusal document, the county, when they look at Medicaid eligibility, only looks at what the Medicaid spouse has. They don't look at the community spouse. So you could have $1 million with the community spouse, they sign a refusal, the county doesn't look at them anymore. They only look at the person in the nursing home. That's what lets us get that eligibility. Now, for that Medicaid spouse.
New York State doesn't like this.
They do not.
The governor of New York State for 26 years in a row has attempted to eliminate spousal refusal. There's actually a federal protection on spousal refusal for nursing home care, but they've upheld it for home care as well. So the same tool is available for home care, but it's not a get out of jail free card because the county and the state then get a recovery right. They can come after you in family court for spousal support, or in Supreme Court if they've paid an amount of money and now we're looking to recoup it. And one of our clients just got a letter from the county. They did a spousal refusal, and the county is seeking 12 months of Medicaid payments to the nursing home. It's about $100,000, and they're knocking on the door asking for $100,000. We are positioned to defend that case, and we'll be defending it. We'll talk a little bit more about this, the appeal side of it and the fair hearing side of it next week. But know that spousal refusal is available, but you have to do it responsibly and knowingly. And there are techniques that we utilize after the transfers are made to the spouse to protect those assets longer term. So how do you get out in front of this, Frank?
You do your trust that we talked about in Medicaid Monday #2, 5 years before anybody needs the nursing home. And then if someone does, then you don't have to worry about all this available assets and resources because they'd all be protected within your trust.
So if you're 5 years out and you think you can stay healthy, then you can get out in front of it, get your trust done, work through that 5 years, and the assets in the trust are exempt. If you do need Medicaid in the short term, there are Plan Bs that we implement where we can use this Rule of Halves transfer and still protect about half of the remaining assets. And that when you do that or whether you do that depends upon how far through the 5-year period you make it. If you make it 4 years and 6 months and you need care, what we're going to do is pay privately for 6 months using potentially assets that the kids can access through the trust and pay that 6 months. And at the end of the 60 months, now you're fully Medicaid eligible and your trust is mature. No two cases are alike. Every client comes here with a set of facts different from the last and with assets and income and families that are different from everyone else. So we really have to tailor this and shape it for each individual client's particular situation.